morning, everyone. Thank you for joining us. I hope you all got your coffee, your breakfast, and are ready to learn all about the fascinating FLSA updates we have for you today. So we're going to be talking about the FLSA under the Trump administration. Just a quick introduction for us. My name is Nallely Rodriguez. I'm a senior associate here at Andrews Myers. I practice almost exclusively employment law, and I advise my clients on FLSA and state wage and hour issues, as well as provide training and represent employers in Department of Labor wage and hour audit.
And good morning. My name is Chitale. I'm a senior counsel here at Andrews Myers. I'm a board certified labor and employment lawyer. And like Nallely, I practice exclusively labor and employment law. And that runs the gamut, but a lot of my time is spent on the Fair Labor Standards Act. And we do a lot of counseling, we do a lot of litigation, of course, but I think Nallely and I both enjoy representing companies in Department of Labor audits, and we're going to talk about that a little bit here today. And we're glad you joined us. We're going to break this presentation down into kind of three parts. The title of the presentation is the FLSA under the Trump administration. So with that in mind, we're going to talk about some Department of Labor updates that I think everybody needs to be aware of. Of course, the Department of Labor is an independent agency, but it's under whatever administration is in power. So that would be the Trump administration. I'm going to refer to this Trump administration as Trump 2. Of course, Trump 1 was 2016 through 2020. The second part of our presentation, we're going to do some legal updates on FLSA cases and issues. And then the third part really is, well, what's the takeaway? What are the best practices for compliance? So with that in mind, let's get going. All right. Everybody knows the Fair Labor Standards Act as the overtime and minimum wage law. Right? But as practitioners, we know it gets complicated. Classifying workers correctly, calculating regular rate of pay correctly, paying minimum wage correctly, especially when it comes to the hospitality industry, for example, tracking time. So we'll talk about some of these complicated issues. You can see that the FLSA doesn't just govern wage and hour. For example, the Family Medical Leave Act is also part of this statute. The Pump Act, which was introduced about 2 years ago for nursing mothers at work, is also part of the FLSA. We'll touch on that a little bit, but let's get to our first update. All right. So we do have a new Secretary of Labor. And I'm going to spend a little bit of time on this, not too much time, but the bottom line is this. It's a little counterintuitive because our new Secretary of Labor is a Republican from Oregon. She is the daughter of a Teamster, and a Teamster, for those of you that don't know, that's one of the biggest unions in the country, the truck drivers. And she was a co-sponsor of what's called the PRO Act. The PRO Act is dead, but what's interesting about this is the PRO Act was heavily pro-union and pro-labor. So it's a little interesting to have, I think, a Secretary of Labor who was a co-sponsor of the PRO Act. She's distancing herself from it now, but I think this goes to one point, and that point is, you know, President Trump's appeal, he appeals to traditional Republicans, but I think he certainly appeals to working class and blue collar individuals as well. And I think his selection of Lori Chavez is an indication of that. The PRO Act, when you get some time, look it up, and you'll see kind of how liberal or progressive it really was. So maybe it's an indication of some things to come, maybe not. Maybe it's just an optics thing, but we'll see. The second bullet point there, wage and hour chief, Andrew Rogers. Now, this is more traditional. Mr. Rogers is a former big firm labor and employment management side lawyer. He was actually an advisor in Trump 1, and he helped publish a lot of Department of Labor opinion letters, which we'll talk about in a minute. So that's kind of more of a traditional pick. And this individual is very well versed in the FLSA and wage and hour laws. We're going to talk about some pending DOL issues that these personnel are going to confront. There might be some appeals that are actually on the books right now that might be dropped by this group. And we'll get into that a little bit. The last person here is Jonathan Berry, Solicitor of Labor. I put these up here because these are not, that where it says Project 2025 proposals. If you don't know what Project 2025 is, it's the Conservative Heritage Foundation. They released kind of like a manifesto outline. And this individual, Mr. Berry, had some ideas when it comes to that. And I just want to kind of go through one or two of these bullet points to help you understand maybe what some of the personnel that are now in the Department of Labor, what their views might be, what they're throwing around. The first one is permit private sector workers to accumulate paid time off in lieu of overtime pay. This one is actually interesting right now. And Nallely, maybe you could speak more on this, but public sector workers are allowed to do this, right?
Right. So for federal workers, the government can provide comp. They call it compensate. They call it comp time. And so instead of paying overtime, they can provide the employee comp time, which is basically like additional time that's paid at the regular rate. So they don't get overtime, but get like some sort of vacation leave, and it's paid at the regular rate. So this is already allowed in the federal government sector. And then Project 2025, one of the proposals is align, the private sector with what federal employers can do.
Obviously, if you need somebody to work overtime but they can't do it, this would be an alternative. This is nowhere near law. I want to emphasize and make it very clear. These are just some ideas floating around. But again, these individuals are now at the Department of Labor. They're at sort of the seat of power. So I wanted to give you a preview of that. One of the more kind of out of the water ones, I think, is require a time and a half premium for working on the Sabbath. I think, that's something that's been floated around. Again, certainly not law yet. But I hope that gives you a taste of kind of what some of these individuals, might be thinking. I think it's pretty much a given that Trump 2 is going to be like Trump 1 in the sense that it's going to be favorable towards employers, but there might be some twists and turns thrown in. Because like I said, Mr. Trump has to appeal to his base, and a large part of his base is comprised of blue-collar workers. So that remains to be seen. All right. We're going to talk a little bit about these opinion letters, Department of Labor opinion letters, and there's a link up there. This is obviously open to the public. Department of Labor opinion letters are not law. They are also not statutes. What they are is basically guidance that somebody from the Wage and Hour Division gives to somebody who calls in and says, hey, I have this issue in my business. Now, you can't use guidance, or you can't ask for guidance if you're actively in litigation or if you're anticipating it. But this could be a good resource for everybody that works in HR, legal. You can go here and research decades and decades worth of opinion letters. And what sometimes happens, though, when a new administration gets in is they withdraw some of the opinion letters from the previous administration. And there's a lot of sort of topsy-turvy that happens. But these are 5 opinion letters that President Biden withdrew from Trump 1. And then the next slide are just some holdings from opinion letters that are still on the books. And these are all Trump 1 opinion letters. So I'm not going to go through each of these. I mean, you'll get a copy of this presentation, and this presentation is eligible for SHRM credit. So Nallely will talk about that more. But when you have a copy of this, go through these. And if you're researching an issue that you're dealing with, there might be an opinion letter on it. So for example, one of the opinion letters says, travel between home and office during the same workday may be compensable when the employee has begun the workday with telework at home. Okay, so this is a letter that was issued in 2019 based on a very discrete set of facts, but it just clarifies something in the law. And if you kind of think about it, it makes sense. If somebody started working at home, telework at home, they are presumably engaged in work, right? And I think what this letter said, what it reasoned was, if they have to travel during that same workday, when they are engaged, that time might be compensable, even if you happen to clock out. So it's full of little nuances like this, and I think they're a useful tool. Any other ones you want to go through, Nallely, or?
I don't. I just want to emphasize the fact that, these opinion letters aren't law, but they're a really good tool for HR, for legal professionals, to get insight as to how the Department of Labor, for example, if you're being audited, how they might view an issue in your case. It'll give you some good insight and see how your issue may come out. For example, if there's an exemption at issue, if you are an employer that has tipped employees, there's a lot of opinion letters regarding tipped employees. So it's just a good resource to have in your pocket.
Okay, so we're going to talk about some of the more topical FLSA issues. This is going to include a discussion of some recent cases, but we're also going to talk about some issues that are always topical. Employers historically, for example, have always had a tough time when it comes to classifying independent contractors correctly, and that continues to be the case. I find joint employer doctrine is always the topical FLSA issues. So when we are going to talk about some recent case law, but we are also going to talk about things that are always an issue. And actually, that brings up an important point. You might have been here for a prior AM talk session about I-9s and ICE and things like that. I think nobody really would disagree if I say that unlike, let's say, the immigration issues or even OSHA issues, we might be dealing with relaxed OSHA standards. Unlike those, the FLSA, you might see some twists and turns, but it's going to be a relatively stable road. We're going to go back to a more business-friendly environment, but it's not going to be like what you might be experiencing if you have ICE showing up at your work office. So I just want to make that point before we get into these issues.
Yeah, definitely agree with that, Bev. So FLSA there's a lot of case law out there. The law doesn't really change from administration to administration. There are just some key topics that Bev will talk about that may be more employee-friendly versus employer-friendly throughout administrations. But generally, FLSA, it's pretty predictable. So let's talk about some recent Supreme Court cases in the FLSA arena. So one of the most recent cases here from the U.S. Supreme Court is EMD Sales versus Carrera. This opinion was released earlier this year in January 2025, and it's a very employer-friendly decision. So let me give you a little bit of background here. We have 3 sales representatives, the plaintiffs, that sued their employer, a food distributor in the Washington, D.C. area, and they alleged that they were misclassified as exempt and denied overtime pay. Now, in their defense, the employer claimed that there was no overtime owed because the plaintiffs were exempt from overtime under the FLSA's outside sales exemption. Now, if you've been doing FLSA compliance for a while, you may know that under the FLSA, the general rule or that there's a presumption that employees are going to be not exempt from overtime. And so generally it's the employer's burden. They have to prove that an employee actually is exempt from overtime pay. So that gives you a little bit of background about kind of what the issues are here. Now, at the trial court level and with the appellate court level, the courts ruled against the employer. And at the trial court level, they said, well, EMD sales, you didn't provide clear and convincing evidence that these sales representatives were exempt. And the Fourth Circuit, which covers Maryland, South Carolina, North Carolina, West Virginia, and Virginia, agreed with that. And they said, yeah, you did. The employer didn't meet that their standard, the clear and convincing standard. And SCOTUS said, wait a minute, that's not right. Actually, the standard that the employer has to prove or has to abide by is preponderance of the evidence. And just to give you an idea of what this means, preponderance of the evidence just means more likely than not. So employers have to prove that it's more likely than not that the employees are exempt from overtime. And if you are a true crime podcast fan, you know that in criminal court, the prosecution team has to prove beyond a reasonable doubt that a defendant is guilty. So we have preponderance of the evidence, and then we have beyond a reasonable doubt. And in the lower courts, they had a clear and convincing evidence standard, which is somewhere between preponderance and beyond a reasonable doubt. But now it's clear that it's not clear and convincing evidence. It's not, criminal court standard. It's preponderance of the evidence, or 51% or more. Is it more likely than not that the employee is exempt? Now, if you just operate in Texas, this doesn't really change anything for you. But if you operate in any of the states in the Fourth Circuit that I talked about, then now you are in alignment with the rest of the country. And the standard for employers is preponderance of evidence. So a very employer-friendly decision here. Now I'm going to talk.
I'll just add one thing if you go back. It does give you insight and it confirms, I think, generally speaking, that the SCOTUS is going to, what they called in a previous case, give exemptions a fair reading instead of, it used to be a narrower reading. And this can almost be thought of as like a part two of that previous opinion. They used to give exemptions a narrow reading that was a little bit more employee friendly. About 5 or maybe 6 or 7 years ago, the Supreme Court said, nope, narrow reading is not good, a fair reading. And now they've resolved the circuit split by saying everybody is under the preponderance of the evidence. So very, very, it's business friendly.
Thank you for that, Beth. So I'm going to talk very briefly about this case regarding arbitration. So just to set the stage here, federal law generally favors arbitration in the employment context. The Federal Arbitration Act is what governs arbitration decisions in the U.S. There are some exceptions, of course, to arbitrating employment claims. For example, employers can't force employees to arbitrate sexual harassment claims before any claims arise. And additionally, one of the other exceptions here is the transportation worker exemption. So generally, transportation workers are exempt from having to arbitrate their claims. So that gives you a little bit of background on the legal framework that we're looking at here. And in this case, the Bissonnette case, which was decided about a year ago, we had some delivery truck drivers who delivered baked goods for a big bakery. They actually produced the Wonder Bread product. And so they sued the Wonder Bread producer and said, hey, we're being misclassified. You owe us overtime. We're being misclassified and we're owed compensation under the FLSA. But here the employer said, wait a minute, you all signed arbitration agreements. So we shouldn't be in court. We should be in arbitration. And if you're familiar with the legal system, arbitration is similar to a lawsuit, but it is in a private setting. In the employment context, employers usually bear the burden of the cost, at least the initial costs for employment claims. And any decision in arbitration is binding on the parties generally. And so here the district court and the appellate court said, no, the workers are exempt. And they dismissed the trial court level dismissed the lawsuit in favor of arbitration, saying you're delivery truck drivers for a bread company. You're not a transportation worker and you're not exempt. So you have to go to arbitration. The Court of Appeals agreed with that decision, but they said they focus on the industry. So they said, you're in the bakery industry, you're not in the transportation industry, you got to go to arbitration. Now here in a unanimous decision, the Supreme Court again said that, hey, the focus is not on the industry. It's actually on the type of work that the worker is doing. And so the inquiry should be, does a worker actually play a direct and necessary role in the free flow of goods across borders? And so why is this important to us? Well, if your company has an arbitration program in place for employment claims, you may want to take a closer look at your workforce and see if there are any employees who play a role in interstate transportation and who may be they may be able to bring a lawsuit and not be compelled to arbitration. Anything you want to add here, Bud?
No, just piggyback on that. It's not about the industry necessarily anymore. So, a lot of people are gonna employ people that drive, and that might be in transportation. So to Nallely's point, you might have more cases in court when you thought you were going to arbitration. So it's just something to look at.
So I'm going to turn it over to Vet now to talk about what's going on with the independent contractor test. I know there's been some changes, so Vet will give you more insight on that.
So the independent contractor test is always been a major Fair Labor Standards Act issue for employers. Back in 2021, under Trump 1, the administration through the Department of Labor adopted a test that was a little bit different than the test that was kind of commonly used. And that test consists of 6 factors. And these factors really try to get at, is the alleged independent contractor working for themselves, or are they under the control of the employer? The more it looks like they're working for themselves, the more they're a contractor. The more it looks like they're under the control of the employer, the more they're going to be an employee. And the practical implication, of course, is you don't have to pay contractors overtime, whereas you may have to pay the same contractors overtime if they're actually employees. So that's why it's important. When President Biden, and I'll talk about the factors a little bit later, but when President Biden took office, he delayed implementing the 2021 rule and then withdrew it. There was a Texas, trial court case about it. The trial court basically held that President Biden shouldn't have done that. The DOL appealed. They ended up replacing it with the rule that was in place before that. It was the totality of the circumstances. They looked at these 6 factors: control, permanency of relationships, skill, ability to basically take work or not. They looked at these factors and they said, we have to analyze this under a totality of the circumstances. And what Trump 1 had done was take the same 6 factors and said, we don't have to look at it in the totality of the circumstances. We're going to zone in and hone in on what are called super factors. And one of the super factors was the entrepreneurial nature of the position. And what's going to happen in 2025 experts are saying that we're going to pause, the Department of Labor is going to pause the legal defense of the 2024 rule, and it's likely to be replaced with the 2021 rule. And the 2021 rule, of course, is a little bit more business friendly. So what is the 2021 rule, and now I guess the Trump 2 independent contractor rule, soon to be? The core factors that are given primary importance: the nature and degree of the worker's control over their work. This has always been the bedrock. It will continue to be. This is the super factor that I was talking about just a minute ago. The worker's entrepreneurial opportunity for profit or loss based on their own initiative or investment. Do they buy their own tools? Are they able to turn down work? Are they free to sign up on a schedule? Do they get penalized if they don't in any way? That was the super factor here. And I think you're going to see that come up again and again. The Trump rule said these are the primary factors. The secondary factors were required skill, degree of permanence, when work is a part of an integrated unit of production. Okay. Now, the Trump administration might view these as secondary factors and the others as primary factors, but this brings up a really important point. The Department of Labor, is not Congress and is not the courts, certainly. And there's, you might have heard of something called agency deference. All this means is, under certain scenarios, a court may defer, in this case, the Department of Labor, to the Department of Labor because they might be the presumed expert, let's say, on what is an independent contractor or not. To the degree that they do that, that's always been debated. But one thing is for sure, under Supreme Court precedent, in a case that was decided last year, there's going to be even less deference to Department of Labor rules and opinion letters, certainly. So all that to say, President Trump and Department of Labor may think that, for example, the degree of permanence of the work relationship is a secondary factor. They could say that all they want, but a court will do their own fact-based analysis. Often, in my experience, the degree of permanence is not a secondary factor. It can be the main factor, or the second place factor, so to speak. So when you're looking at these opinion letters or regulations, yes, they're going to be persuasive. They may be well reasoned, but remember that courts are going to do their own analysis. There's precedent, longstanding precedent on the independent contractor test. So don't ignore the administration, the regulations, but keep that caveat in mind. So that concludes the independent contractor test. I think one other, and I've dealt with this a lot for some reason in the last year. How are we doing on time? Yeah. 8:36. Okay. I've dealt with joint employer issues a lot for some reason the last year in the FLSA context and out of the FLSA context. The joint employer doctrine is pretty simple in theory. You sue business X, but then you claim business Y, which may be a subsidiary, it may be a parent, it may be a sister company, based on the facts, also jointly employs the worker. And another nuance of the FLSA is, guess what? Individual supervisors can also be joint employers. So you can have individual supervisors liable. The Republicans and conservatives traditionally have not liked this because it really kind of makes liability possible for a lot of entities, not just the quote unquote primary employer. I think you're going to see joint employer kind of come back into focus a little bit under Trump 2. The administration officials, Republicans in Congress, are going to try and limit and narrow who a plaintiff can sue as a joint employer. And an example of that is this act by Representative James Comer, Save Local Businesses Act. This act is currently stalled somewhere since 2023, but I want to point your attention to what the act actually says. This bill provides that a person may be considered a joint employer in relation to an employee under federal labor law only if such person directly, actually, and immediately, and not in a limited or routine manner, exercises significant control over the essential terms and conditions of employment. Pretty strong language, very kind of, it narrows down. It probably eliminates a lot of individuals and entities who might be considered joint employers otherwise. And I'm not saying this act is going to go anywhere, but I think, I wouldn't be surprised if someone introduces more legislation that kind of mirrors this, or at least maybe halfway mirrors this. And that's something that we all need to be aware of, is to see joint employer back in the focus. All right. There's also been a lot of rulemaking in the last year about salary thresholds. So just want to talk about that for a few minutes. Let's start with the basics. I think Nallely mentioned this. The best ever explanation I heard about overtime exemptions is this. You start off with the presumption that everybody is owed overtime, and then you bite into that presumption and create your exemptions. And there's a lot of exemptions. The three main exemptions are the white collar, so-called white collar exemptions for executive, administrative, and professional employees. All right, so that's the background for that. Now, what happens is, if you want to classify somebody as exempt, you have to do three things. First, you have to pay them on a salary or fee basis. And a lot of people don't understand this because I guess it's kind of not intuitive. If you don't pay somebody by a salary or fee basis, you're running the risk that they are, there's some other exemptions that might come into play, but everything else being equal, you're running the risk that these people are owed overtime. Okay, so the first thing is you have to pay them a certain way. Second thing is you have to pay them a certain amount as a salary. And the third is you have to analyze what they actually do, the duties test. So what the Obama administration way back in 2016, it seems, tried to do was raise the amount that you have to pay people to that figure, 47,000 and change, after a 2-year rulemaking process. So as you can imagine, this would have brought a lot of people in, or rather, I guess you could put it either way. It would have made a lot of people not eligible for overtime, right? So before it could take effect, there was a Texas court that enjoined this, enjoined the Department of Labor from enforcing it. The Trump administration comes in and actually raises the salary threshold as a compromise. So remember, President Trump has a wide appeal and a big appeal in the working class and the blue collar population. So again, it might be surprising that a Republican came in and raised the salary threshold, but maybe not, considering that. So as a compromise, they did raise it to 35,568. The Biden administration comes in and wanted to raise it even more. And if you remember, this is kind of a big hoopla that was going around happening last year. By January of 2025, if the rule had stood, if the Biden era rule had stood, that amount would have been $59,000. And that would have taken millions of people into the exemptions. And that would have been distressing to a lot of, Chamber of Commerce types, business people. And the argument that the employers made was that this higher threshold basically makes the duties test redundant. Okay. And actually, that argument turned out to be very persuasive because towards the end of 2024, and Eastern District of Texas nationwide struck down that final rule. Of course, President Biden was still in charge at that point, so his DOL appealed that rule. Okay. Now, obviously, President Trump comes in January of 2025. And as a result, what we can anticipate is one, that appeal might be dropped. And two, no future increases to the salary levels. What does that mean? That means we're going to stay at 684 a week or equivalent to 35,568. And you could be relatively comfortable with that. That's, I don't think that's going to change. Cost of living does continue to rise, and all the chaos that's happening. I try not to say never, but I'm fairly comfortable that I don't think you're going to see the salary threshold change yet. The HCE, if you're wondering, is just a highly compensated exemption. If we had more time, we would definitely get into that. But that is the salary threshold for a highly compensated individual. Anything you want to add on this, Nallely?
I don't. I agree that I don't think we're going to see a change in this. So for now, just if an employee, if you categorize them as exempt, just make sure they're meeting that 684 per week threshold.
All right. We're going to talk about a few more cases before we get into our third part of the presentation.
Yeah, so I have one more case for you all, and it discusses travel time. So this is in the Seventh Circuit. This opinion came out in October of 2024. And again, for those of you who only operate in Texas, this doesn't really change much for you. But if you're in the Seventh Circuit, this case aligns the Seventh Circuit with the rest of the country. So in this case, we have employees who sued. It was a staffing agency employees. So it was a staffing agency for construction clients. So important for those of you in the construction industry. And we have these temporary workers that were required to travel to project sites in remote locations. And they stayed at these remote locations for days at a time and up to weeks at a time until the project finished. And then they would either travel back home or they would travel to the next project site. And the staffing agency was not paying these employees for the travel time to the remote project sites. And so they sued and said, hey, we should be compensated for the travel time. And if it puts us over 40 hours a week, then we should be getting overtime as well in the weeks that we travel to the remote sites. The employer said, okay, the employer was not paying for this. And so what the Seventh Circuit held here is that employers are required to compensate for that travel time when two factors are apparent. So one is that the employee remains at the remote location site overnight. So if they come home at the end of the day, even though if the location is remote, the employer doesn't have to pay for that travel time. But if these staffing agency workers, if they're staying overnight at the remote location, then it has to be compensated. And the other requirement here is that the travel time has to occur during the employee's normal work hours. So if there's a project site and the normal work hours are between 7 to 5, 7 to 6, and the employee is traveling to the remote locations between the hours of 7 to 6, even if it's on a weekend, and they're staying overnight, that time has to be compensated. So again, if you're operating anywhere really in the US now, the rule is travel time has to be compensated if the employee stays at a remote location overnight, if they don't come home at the end of the day, and the travel time is between that employee's normal work schedule hours. Anything you want to add here, Bed?
I'll just say that I've had, I think, 3 clients that I've counseled on travel time in the last maybe 3 months. And then, a partner, one of our partners' clients also had a travel time case that was brought that we worked on. So, I mean, travel time is not to be underestimated. A lot of times employers simply don't consider it. And employees don't consider it either, but they might learn what the law is after they've left and might realize that they have a lawsuit.
Right.
So travel time is underrated.
Agreed. And just to add, the general rule is normal commute time to and from work, between work and home, that's not compensable. But this rule is a little bit different. Again, it's someone who stays overnight at a remote location and the travel is during ordinary work hours. But otherwise, your general commute to and from work is not going to be compensable. Now we're going to get into some best practices. So really quickly, remote work, it's, been a hot topic in the past few years, especially given COVID. A lot of companies started working remotely, and now we're trying to bring employees back into the workplace. So remote work is here to stay. We don't see it going anywhere. And so we just want to give you some tips on managing remote workers. The biggest challenge that we see in our practice with remote workers is timekeeping. So because the employees are at home, we don't have the supervisors on site making sure that they're actually, clocked in and doing work. Employers have a lot of trouble with timekeeping. So the FLSA, again, it requires that employees be paid for all time work. And so we need to be cognizant of any off the clock work, working during meal breaks. Those are a lot of the issues that we see. And so we'll talk about it in a different slide, but we just need to make sure that we have policies in place that address, if you don't want employees to work during meal breaks, then that needs to be in your policy. If you want to discipline employees for working off the clock, that's a possibility. We just need to make sure that they're paid for any time worked and then address, the policy violation. These are all issues that could create overtime liability for your non-exempt employees, and we just want you to be aware of it. And then the last point here on multi-state employer considerations, I just want to point out the FLSA provides a floor for employers. Texas doesn't provide any additional rights to employees, so they're on the same, playing level as the FLSA. But there are other states that provide additional rights to employees. For example, California has a greater minimum wage than federal law. And so if you are operating in multiple states, we just want to make sure that you're aware of your state obligations. And if the state law and regulations provide greater rights for employees, then you need to be following that state law.
Yeah, and it's a lot of states. I mean, you got California, Oregon, Washington, Colorado, a lot of states on the East Coast. So it's more than a dozen, that's for sure, when it comes to providing greater rights, like Nallely was saying, than the FLSA. When it comes to minimum wage, overtime, when it comes to double time, work breaks, there's a lot of multi-state issues. So you could have one of the advantages of remote work for an employer is you can find talent in other states. That's great because it's about talent, right? Okay, but if that person is working in Colorado, you need to consult about Colorado law, because even if they're working for you and you're in Texas, the question is whose laws apply. And generally, state laws will apply to workers in that state. So those are the multi-state employer considerations.
Agreed. And I'll give you an example. So I had a client that operates in Washington, in Texas and Washington. And Washington actually has higher thresholds for exempt employees than federal law. And so they had to adjust their compensation to make sure that the employees were still exempt, but being paid a little bit more because Washington provides for that. Another example that I want to point out for you all is if you're operating in Illinois and Texas. So let's say you have a Texas employee, they're remote, and that employee reports to a supervisor in Illinois. In that situation, the Illinois Pay Transparency Act will apply. And so there are just different laws in different states, and you need to make sure that you're complying with the most stringent ones. So one of the best practices that we always advise clients to do and that we actually counsel clients through is conducting internal audits. And why are internal audits important? Well, we want to make sure that your paperwork matches the workforce reality. And so we want to make sure that timekeeping records are accurate. You may have an employee who's clocking in 8 to 5, but you regularly see them at the office after 5 o'clock working. So in those situations, we want to make sure that their employees are clocking in and out on time and that the paperwork reflects the actual hours that are worked. And separate from reviewing payroll records, you can also be reviewing job descriptions and talking to employees about their job duties. For example, during a DOL audit, the DOL is not only going to look at your pay records, your timesheets, they may also interview employees and make sure that what they're actually doing on a day-to-day basis, if they're exempt, if you're claiming that they're exempt, that those duties that they're doing are non-exempt, that are exempt duties. Want to add something to that?
No.
Okay. And if you do find discrepancies, we just need to make sure we take care of that in a timely manner. We always advise employers, if they find employees are working off the clock or overtime wasn't calculated correctly, that we fix those issues pretty promptly. The last note here, if you use a timekeeping system, I know a lot of clients use ADP or some competitor of ADP. We need to also make sure that the software technology is accurate, because any errors in that, in the timekeeping reports and the pay, even if they're calculated by ADP, that error is going to cause liability for you as a company. So making sure that we are also auditing our software and timekeeping systems is important.
So, I mean, this one is pretty self-explanatory. I don't want to spend too much time on it, but definitely review policies and procedures. A lot of the non-litigation work that we do at Andrews Myers in the employment section is about the internal audits. We do those for our clients, and we do review these policies. A point I want to make is about the Department of Labor enforcement. I think what you're going to see happen under the Trump administration is, I don't think that the audits necessarily are going to go down drastically in number, but the nature of the audits and the tone that's taken is going to be different. It's going to be about compliance, and if you're meeting the bare minimum. The emphasis is going to be on rewarding compliance, I think, versus I think in the Biden administration, it was more on kind of penalizing non-compliance. The emphasis that this was intentional, willful, liquidated damages, 100%. I think the emphasis is going to change. And to that point, I think everybody should review their policies and procedures just in case there's an audit. Training, very, very important. We do trainings quite a bit. Sometimes, unfortunately, they're after the fact. They're mandated trainings for people that have been audited, for companies that have been audited. Nallely and I just did one maybe 6 months ago for a company that went through a painful audit process, and we resolved it, but part of that was mandatory training. It'd be great if you don't have to do that mandatory training. That you just did it as a precautionary measure, and to make sure your employees are trained, your managers are trained, and we can be a resource for that.
Just quickly adding on the training. Yeah. So you might wonder, why do managers need training on FLSA? Well, managers play a key role in making sure that your timekeeping records are accurate, that employees aren't working off the clock, that you manage overtime expectations as well. So it's important that they're trained and they have a general understanding of the FLSA and what it requires from the employer's perspective.
And another point that the managers themselves might want to hear is, under the FLSA, you can be sued individually as a manager. But in most cases, your employer is going to kind of take care of the defense. But unlike Title VII, for example, where managers and supervisors can't be sued individually. That is not the case under the FLSA. So very important point there.
And that last point there, training can be used to rebut willfulness. So generally under the FLSA, employers can recover wages going back 2 years. If they can show that the employer has made willful violations, they can go back 3 years. And so training can be used to rebut that willfulness allegation.
All right, this is our last slide. It's just a takeaway slide. I want to emphasize some key takeaways here. The first point being that, look, unlike the radical changes that you're seeing when it comes to immigration enforcement, I don't think that's going to be the case here. OSHA, you might see more relaxed standards. I mean, there's some things that the EEOC are doing that have never been done before, with DEI and stuff like that. FLSA is a little bit more predictable, but at the same time, think about some of the twists and turns that might come your way that we've talked about. Just one other thing comes to mind. This was just a campaign sort of thing, but ending taxes on overtime and ending taxes on tips. I don't know how you do that, like logistically, and how you get that through politically, but that's something that was there. You might see an increase in minimum wage, low possibility, but it could happen. One of the hallmarks, I think, of this administration, and this is not a political point, but a practical point, is you're going to see stuff that's not been done before. So keep that in mind. Keep in mind the opinion letters. They're a useful resource, but also keep in mind administrations come and go. Courts have longstanding precedents when it comes to these issues. I just made the point about compliance. I think you're going to see a shift in tone. Traditionally, Republican administrations are concerned with overtime and labor violations, but their tone is a little bit different. It sort of rewards compliance rather than sort of trying to really punish noncompliance. That's just a generalization, but I think it's true. Certain topics are always going to be hot and are very fact intensive. Misclassification work and independent contractor comes to mind. One other thing, I do FLSA class action and collective actions a lot. And off the clock collective actions have, I looked at a stat for this. It's not coming to mind the exact stat, but off the clock class and collective actions in Texas and out of Texas, you've seen a sharp uptick in the last 5 years. So that's going to continue to happen. Certain topics are going to become more and more important. Tracking time for remote work is going to be one of those. Gig economy has been really hot for the past few years. All of this, the last 2 points lead to this. Everything we're talking about here is to save the employer time and money. Collective actions, class actions are expensive. The FLSA has attorneys' fees to prevailing plaintiffs. That's not going away. That means it's expensive. Even if you win, you're going to incur attorney's fees to your attorneys. If you lose, you might be paying the other side's attorney's fees. So the best thing to do is monitor these developments. Go back to your teams. When you audit, don't just look at paper. Interview people. Get out there. Get to decision makers. If you are a decision maker, make sure your team implements this. Make sure you are complying. And make sure you train your workforce. And I think if you do those things, whatever comes, you'll put yourself in a better position to deal with it. So that's our last slide. I want to open it up for questions if there are any.
And just while we're waiting for questions, we do have the SHRM certification number. It'll be put in the chat box, as well as you'll receive it in an email with the slides from this presentation.
And if you think of a question in the next few minutes here, great. If not, these are our emails. Reach out to us. We do litigation defense, but we also do a lot of counseling when it comes to these and other areas. But it's just been a pleasure to be with you this morning. And we thank you for coming in early and making the time for us.
Okay, thank you, everyone.
Thank you, everyone.